Let's delve into an issue affecting many South Africans, the predatory practices of illegal micro-lenders, often known as mashonisas. The National Credit Regulator, the NCR, has announced a significant intensification of its efforts, working hand in hand with the South African Police Service to combat these illicit operations. The NCR has expressed serious concerns over the proliferation of illegal lenders who exploit vulnerable individuals, often without conducting proper affordability assessments and charging exorbitant interest rates. These unregistered entities operate outside the bounds of the National Credit Act, we're told, making their agreements unlawful and unenforceable. It's a mouthful, what I've just said. So we'll go through it step by step. Why not? I'm joined now by Nthabiseng Sefudi, Senior Legal Advisor at the National Credit Regulator, as well as Leonie Van Pletzen, who is CEO of the Microfinance South Africa, MFSA. Good afternoon to the both of you, and thank you for joining me. So let me start with you, Nthabiseng. Just from your perspective as the NCR, tell us about the prevalence of these practices of illegal and unlawful, lending, the practices of the so-called mashonisas, and what are the lanes that are straddled in as far as the law goes here?
As the Investigations and Enforcement Department, in fulfilling our mandate, we go through various provinces and with the assistance of our major stakeholder, which is the SAPS and the Hawks, where we conduct raids, and that is where we have identified, especially with the current state of the economy, the rise of these unregistered credit providers and how they thrive in charging exorbitant interest and not conducting any affordability assessments. And we have seen that they take advantage of the current state of the economy because they know that when people need loans, they will not go to the banks or any registered credit providers. And that is where these mashonisas are there. They will grant these quick loans without conducting any credit checks or not conducting any affordability assessments.
Before I bring in Leonie, let me stick with you and Nthabiseng. Say a bit more then. If a person engages in micro-lending, so the smaller amounts of loans that they extend to other people and perhaps charge interest on that, is that necessarily unlawful as far as the law goes? Where are the boundaries? What makes it unlawful? What would a person need to do to be able to do that, engage in those practices without breaking the law?
Firstly, those credit providers would need to register with the National Credit Regulator in order to provide or extend credit legally. Secondly, when I mentioned the fact that they charge high interest rates, so in terms of the Act, when a consumer comes and requests a loan, they have to charge 5% per month. And in the same year, where the consumer comes again for a subsequent loan, they need to charge, the credit providers need to charge 3% per month. So that is where we will be able to distinguish whether a credit provider is registered or not. Now, these mashonisas, so to say, they charge double 50% or they charge 30%, and again, they are not registered with the regulator. That is where we identify these trends of these mashonisas.
Run through the numbers for me again. I'm sorry, I may have missed them. What's the threshold of interest that makes it against the prescribed principles of law?
So for when a consumer goes to a registered credit provider, the interest that is supposed to be charged is 5% per month. And in that very same year, if the consumer comes again for a subsequent loan, the credit provider must charge 3% per month interest.
All right, gotcha. Leonie, let me bring you in. You operate within that space of microfinance in South Africa. What's the context for what we are talking about, the allure of micro loan providers, some registered, some compliant, and others not so?
Thank you so much for the opportunity. So MFSA represents about 1,800 legal credit providers registered with the National Credit Regulator. And we really just want to commend the NCR for focusing a lot on the illegal market. we are really seeing that consumers are struggling and they are making use of this illegal market. Our members operate within an environment, like she said, the first loan 5% and the loans thereafter only 3%. What we are seeing now is, these mashonisas, these illegal credit providers, keeping card and PIN, withdrawing the consumer's money, and basically charging interest of more than 100 to 200% per month. So there's a major concern. The consumers are struggling, and I just want to warn the consumers that the first thing that they have to do is they must check for the NCR registration certificate before accessing credit from an illegal credit provider. They must also know that they do not have to repay these mashonisas. The NCR is there if there is enforcement that needs to take place.
Leonie, is it perhaps not an unexpected and inadvertent byproduct of tightening the controls around affordability checks, the criteria, putting it down in writing as a credit agreement, and sticking to the letter of the law, that we're seeing perhaps the continued proliferation of not just microfinance providers, but actually those that are not registered?
So the association definitely doesn't want to curb innovation, and we are seeing very innovative products there. I think what the problem is currently is why there is so many illegal credit providers as well is because the rates and fees of microfinanciers has also not been reviewed in 10 years. So what's happening is credit providers cannot afford the cost of compliance anymore, and then they go to the illegal and the underground market, basically that doesn't govern them at all. Now, this is a major concern for the association, so we are talking to the NCR and the DTIC to make sure that the proper reviews do take place so that these illegal guys can get registered and it's actually worth their while to provide credit to consumers. However, this does not justify it. We are seeing exploitation of huge numbers. So usually you would think of mashinisa, it's 1,000 Rand, 2,000 Rand. We are seeing amounts of 30, 40, 50,000 Rand, even more than 100,000 Rand. So there's real exploitation and it is harming the consumer. And that then has a ripple effect into gambling because the consumer can then not repay his loans, and then that goes into gambling. So I think the review of rates and fees is very much necessary in order for these credit providers to afford the cost of compliance. However, it's not an excuse if you're non-compliant.
Sure, gotcha. Crystal clear there, Leonie. Nthabiseng, weigh in on that. Reviewing the cost of compliance and the applicable rates in the manner that Leonie was describing in the last few minutes. To what extent does that have the effect of perhaps driving some lenders from the regulated, registered microfinance space to the unlawful space?
Thank you very much for that question. And I like what Leonie touched on, the fact that as the NCR, we are currently busy with amending the Act. Yes, it has been years since it has been amended, and we have been aware of these challenges that are currently happening. Moreover, with taking into consideration the economy that we're currently in. So that I like what also Leonie mentioned, that it does not excuse the fact that these mashonisas can then take advantage and charge all these exorbitant fees. So as the regulator, we are on the ground, we do work with stakeholders, and currently where we can, we do enforce the Act, and we go and enforce at the National Consumer Tribunal, also bearing into account that we are busy with amending the Act.
All right, I've got to thank both of you. What an enlightening conversation we've had this afternoon with Nthabiseng Sefudi, Senior Legal Advisor at the National Credit Regulator, as well as Leonie Van Pletzen, who is CEO of Microfinance South Africa.